Hi guys, welcome to the channel. Please don't forget to hit the like button and subscribe if you haven't already. So, y'all already know what we're here for. This is going to be another update concerning the Love and Marriage Huntsville cast. It is the case with Maurice Scott on network and the content creator from YouTube. We're going to get straight into the video. So, a lot of you guys had questions when we would get the update on the case, and we're going to kind of go over a new motion that was filed actually. And I think we have an answer to that question you all had. So a lot of you wondered, why did they decide to go after OWN Network instead of Carlos King and Kingdom Reign? So you guys, when Maurice first filed his lawsuit, he named a few people. He named like 3 people, but he also had some placeholders for fictitious parties. He had them listed A, B, C, D, and however many slots he reserved, because he claimed he was going to name some people in the future once he found out their identities. So the document is on the screen. And as we can see, this was electronically filed on 11/13. This was filed in the Madison County Courthouse. You see Maurice Scott, you see Miss Black Titanic. And when we go to the next document, you see them name Oprah Winfrey Network LLC, names used. And then we see it says, in fictitious counter defendants A, B, C, and D, in any and all fictitious parties or entities who are vicariously or otherwise imputed with allowing, ratifying, and or promoting the conduct of Maurice Scott, jointly, individually, and severely liable. The names and identities of fictitious parties will be named after further discovery. Plaintiff, counterclaim, defendant, third party defendant. I don't think that Carlos is out of the woods yet. So she can name some other counter defendants in the future. So who do you think those other counter defendants may or may not be? Carlos needs to be celebrating just yet. I don't think he's free and clear. So you guys, the last update we did, it was a motion filed by OWN. They filed a motion to support the motion to dismiss. So this is actually Miss Black Titanic's response to that motion. And we see it says, response to the 11/13/2024 third party defendant, Oprah Winfrey Network LLC, and the document titled reply in support of motion to dismiss. And it says Miss Black Titanic's motion to declare that OWN has answered her 21 count complaint. So you guys, let's get into it. It says, comes now, Miss Black Titanic, through the undersigned counsel and without wavering any previous argument, submits the following. Redundant filings are now moot, as they form an answer to the 21 count amended complaint. Third party OWN has previously filed a motion to dismiss for failure to state a claim, and now a reply 2 days before a hearing on OWN's motion to dismiss for failure to state a claim, which clearly provides an answer to Miss Black Titanic's 21 count amended counter cross complaint, also referred to hereinafter as the complaint. A motion to dismiss for failure to state a claim is clearly moot when the motion and responses between the parties preview the very issues that will be disputed and raised at trial on all 21 counts. OWN is seeking proof, as shown in its motion to dismiss and more clearly shown in its 11/13/2024 reply, the debate of issues, denial of liability, and the seeking of proof is a form of answer, despite the title or label provided. And then it says, OWN's reply filing is a clear intent to litigate the anticipated issues, deny liability, demand proof, and a clear answer to the complaint. OWN apparently wishes to file an answer, and OWN's motion to dismiss in reply should and must be treated as an answer to the pleadings. OWN cannot have it both ways. OWN cannot respond to the issues anticipated in the complaint, demand proof, and then move to dismiss the complaint. OWN's filings and now OWN's additional filings and body of said filings are further confirmation that an answer has been submitted by OWN despite the heading and the titles of the documents. Sidebar, okay. They coming in hot with this motion. And they're applying the pressure right back to OWN. And also they mentioned that OWN filed that on the 13th, which was 2 days before they were set to be in court. So today is actually the 15th, which they are due in court today, guys. So let's send some good energy over to Miss Black Titanic that she comes out victorious in this matter. As OWN has made a 11/13/24 reply or repeat filing of some sort, further answering and defending OWN against the allegations in Miss Black Titanic 21 count amended counter cross complaint. I'm assuming it says referred to hereinafter as the complaint. It says reply are merely answers, demand for proof and legal arguments on the anticipated issue before discovery. OWN's inseparability is undisputed / settled. Third party OWN has been deemed an inseparable party. This court granted relief and joined OWN to this lawsuit on 6/18/2024 as a necessary party without an objection from any party. OWN's inseparable status is settled. And then it goes on, number 2, the sufficiency of Miss Black Titanic's complaint has been ruled upon in her favor on 6/24/24. This court entered an order on 6/24/24 denying Maurice Scott's motion to dismiss for failure to state a claim. Miss Black Titanic's complaint survived said motion and was individually, jointly, and severely joined with OWN on each of the 21 counts and is repeated throughout the complaint. OWN has been sufficiently put on notice in each count that OWN is individually, jointly, and severely liable. OWN is fully appraised of the 21 count and has begun to demand proof and defend against the allegations as shown in OWN's motion to dismiss and now's OWN 11/13/24 reply. OWN has a clear understanding of each count / claim and that they will be issues raised concerning OWN's liability. Those issues and theories of liability will be heavily litigated, and OWN even more clearly intends to debate those issues and theories as shown in its reply filed on 11/13/24. In the body of each of the 21 counts in Ms. Black Titanic's complaint, the complaint alleges that OWN has controlled, ratified, and adopted the conduct of Maurice Scott, and that OWN and Scott are jointly, individually, and severely liable. Each of the 21 counts adopt the allegations in the complaint, including paragraph 1, that Scott was an agent, representative, and employee of OWN, which is more than sufficient to put OWN on notice. OWN has concealed that Scott was engaged in misconduct and or has OWN has been ruled as an inseparable party. It is clearly anticipated that evidence will be presented to confirm the relief demanded from each of the 21 counts. If OWN wants to explore the sufficiency of evidence under a theory of vicarious liability or respondeat superior, then OWN should cooperate and turn over all related evidence during the discovery process. As the court recalls, counter-defendant Maurice Scott has been put on paper notice of the contents of Miss Black Titanic's sufficiently pleaded 21 count and claims for relief. Miss Black Titanic will prepare for a trial where she will prove her allegations made in her complaint. The court ruled in Miss Black Titanic's favor on 6/18/24 and 6/24/24 regarding the sufficiency of her complaint and the inseparability of OWN. OWN is now actively debating the issues surrounding the same complaint and demanding proof. Miss Black Titanic's complaint has served its purpose. Now that Miss Black Titanic has sufficiently put on notice of her 21 count complaint and claims for release, and now that OWN has responded to the anticipated issues therein, making a demand for proof. Miss Black Titanic is entitled to use the discovery process to obtain evidence to present at trial to further support her claims. Miss Black Titanic is entitled to demand that OWN turn over all relevant discovery concerning each and every count in her complaint. OWN's motion to dismiss discusses vicarious liability and respondit superior as theories of a law anticipated during the litigation in this action. OWN will not escape vicarious liability or respondit superior liability when the evidence is presented to prove such theories. The court cannot dismiss complaint for failure to state a claim while OWN is actively litigating the issues in the same complaint. OWN appears to have an understanding as to each of the 21 counts and has begun their defense accordingly in its motion to dismiss in reply. The complaint has served its purpose. Miss Black Titanic therefore anticipates that demands will be made during the discovery process that will allow the presentment of evidence at trial to support each of her claims. At trial, should Miss Black Titanic provide evidence to prove each of the 21 counts in her complaint, Miss Black Titanic will prevail on each of those counts. A motion to dismiss, I'm not going to read that, y'all. This look like some case law that they're citing. It says OWN has no basis to conclude that Miss Black Titanic can prove no set of any facts that would entitle her to relief under some cognizable theory of law, while OWN is actively answering the complaint, demanding proof, and has not even participated in the discovery process. Miss Black Titanic only needed to plead a short, plain statement of claim under Rule 8 of ARCP and has clearly and overwhelmingly met this requirement. OWN is misapplying some standards of review that simply does not exist for a motion to dismiss for failure to state a claim. In OWN's introductory section on page 1 of OWN's 11-13-24 reply, OWN states and takes a position that the issues have been obfuscated and suggests that this court conduct some sort of analysis of this issue. Thereafter, OWN leaps into a long debate on the theory of vicarious liability. OWN seeks to form an answer to the 21 count complaint and seeks an era to analyze issues before the discovery process has begun. On page 1 of OWN's 11-13-24 reply, OWN states and takes a position that the issues have been obfuscated. It is the discovery process and not the complaint itself that fills in factual details. OWN is mistaken in its reasoning that a complaint brings a finality to all available facts that will be later used to prove each count of the complaint. This mistake is very clearly confirmed in OWN's 11-13-24 reply filing. OWN is seeking proof of all other facts needed to win the case. This is better known as an answer and demand for proof, evidentiary finding, or analysis on issues and seeks far more than what is required from the face of a complaint. OWN begins page 2 of its 11-13-24 replying, suggesting that Miss Black Titanic complaint does not prove certain theories of law on issues such as agency, employment status, or the scope of employment. OWN will need to participate in the discovery process and then make its legal argument at trial or when the court will hear the evidence of the case. OWN is clearly on notice of the 21 counts and is now attempting to confuse the standard of review or the next steps in the civil litigation. OWN has clearly filed an answer and demand of proof, mislabeled as a motion to dismiss and a reply. A hearing on such motion is now moot, where OWN has already demonstrated a clear notice of the 21 counts and a willingness to participate in the anticipated issues surrounding the litigation of each of the 21 counts in the complaint. And then it says, wherefore the above premises considered, Miss Black Titanic seeks an order denying OWN's motion to dismiss, a order declaring that said motion is moot, and a order ruling that OWN has, by the very definition of an answer, has in fact filed an answer and a demand for proof to Miss Black Titanic's 21 count cross complaint and any other relief deemed appropriate. Okay, let me go ahead and take this off. So what did you guys think about that motion? In my opinion, what I took from what I just read was that Miss Black Titanic's lawyer said, now you're in it. If you didn't want to be in it, why are you demanding proof? And basically saying OWN jumped the gun. They're saying, in my opinion, that the things that OWN are now asking for would be settled in the discovery process, and they did not have to put it in their original cross complaints. That's just what I'm getting from this. So I don't know. We'll see how this all play out. They were doing court today. I'm gonna keep you guys updated. It's getting sticky over here for OWN and Maurice, and it seems like Carlos could actually be pulled in on a later date, in my opinion. I believe that's why they have the placeholders that we went over at the beginning of the video. So y'all like the video and let me know what y'all think about all this down below in the comments, and I'll see you guys in the next one. Bye.